Okay, I'm going to call the meeting of the Sentencing Guidelines Commission to order. The date is January 13th, 2021. This is a hybrid meeting. We have some folks online and some folks here in the Capitol. And we will start the meeting by calling the roll, so I'll ask Director Wrights to do that.
Roll call. Vice Chair Estrada.
Present.
Estrada present. Blakey, Commissioner Blakey.
Present.
Blakey present. Hansi.
Present.
Hansi present. Knudsen.
Present.
Knudsen present. Ladd.
Present.
Ladd present. Larkin.
Present.
Larkin present. Middlebrook.
Present.
Middlebrook present. Moore.
Present.
Moore present. Morath.
Present.
Morath present. Schnell.
Present.
Schnell present. Chair Mitchell.
Present.
Chair Mitchell present. Madam Chair, there are 11 members present, no members absent.
All right, thank you. Before we get to the approval of the agenda, because our last meeting was so lengthy, I made a huge oversight and I neglected to introduce our new member to the commission, Brooke Morath, who is our new public member who's appointed by Governor Walz last month. And it is tradition on the commission that when we do that, we all introduce ourselves to the new member as well. So I'd like to do that briefly, and then we'll move on to the order for the day. So Brooke, if you wouldn't mind just sort of saying hello and telling us who you are, then we'll all take a turn at that too.
Again, I'm Brooke Morath here. I'm very excited and honored to serve alongside of all of you. And my day job is I'm a research tech, and just recently finished up a master's degree in public health policy and ethics. So this seems to be pretty fitting.
Excellent. Thank you. Welcome to the commission, Justice Moore.
Thank you, Chair Mitchell. Well, welcome to the Sentencing Guidelines Commission. I'm Gordon Moore, Associate Justice of the State Supreme Court. I'm actually also somewhat new to the commission. I started as a Supreme Court Justice back in August of 2020 after a lengthy service in Nobles County as a district court judge and county attorney.
Thank you. Commissioner Middlebrook.
Welcome, Commissioner Morath. I'm Catherine Middlebrook. I am the Chief Appellate Public Defender, and so I am the Public Defender representative on the commission. I guess I've been here now, I don't know, Meg probably knows better, since 2014. I think that's how long I've been on the commission. And my office does all of the criminal appeals for indigent clients throughout the entire state. So we appear frequently in the Court of Appeals and the Supreme Court, and also back in district court on post-conviction matters.
All right. Thank you. Commissioner Schnell.
First of all, welcome. My name is Paul Schnell. I currently have the honor of serving as the Commissioner of the Minnesota Department of Corrections, and I welcome you to the Commission.
We'll go online. Judge Knudsen.
Good afternoon, Commissioner Morath. David Knudsen. I've served as a state senator for 12 years. I practiced in general practice of law for 18 years, and I've been 18 years on the district court down in Dakota County. Madam Chair, I thought there was a requirement that new commission members had to sing their high school fight song.
I didn't hear what you said. I didn't hear what you said, and it sounded like it was funny. Say it again.
It wasn't that funny, but we have a tradition in our district. We ask all the new judges to sing their high school fight song. So,
you don't have to do that if you don't want to. Oh, that's funny. All right, thank you so much. Commissioner Ladd.
Thank you. So I'm Kyra Ladd. I'm the Wadena County Attorney, and I appreciate sort of spending a little time getting to know you. I am the County Attorney Representative on the Commission, and one of the newer appointees by Governor Walz to this Commission, representing all 87 county attorneys in the state. So welcome to the Commission.
And Commissioner Larkin.
Welcome, Commissioner Morath. I am Michelle Larkin. I'm a judge on the Minnesota Court of Appeals. This will be my third report to the legislature, so I've been here nearly 3 years. I've been on the Court of Appeals as a judge for close to 14 years. I was a district court judge in Wright County for 3 years before that, and I started my practice career as a public defender in Hennepin County, where I was for 13 years before being appointed to the bench. Welcome, and we appreciate your voice on these very important issues.
Thank you. Commissioner Hansi.
Welcome to the commission. I'm Commissioner Tanya Huntsey, and I am directly impacted by the criminal legal system. I'm also the Director of Health Equity for a national nonprofit, and really excited to have you on the commission.
Commissioner Estrada.
Good afternoon, Commissioner Morath. I'm Valerie Estrada. I am the probation officer representative. I've been on this commission, I believe, since 2016. I have, a long history of working in different units of probation, from specialty courts and high-risk supervision, and I am now a corrections unit supervisor, supervising one of our traditional high-risk units in Hennepin County.
Thank you. Commissioner Blakey.
Good afternoon. My name is Brooke Blakey. We share a wonderful name. Nice to meet you. I am the representative for the law enforcement component of the commission as well. I'm newly appointed. This is my first year, and I work with Metro Transit Police Department. Welcome and thank you.
All right. And then I did get a chance to meet you. I'm Kelly Mitchell, and I'm Executive Director of the Robina Institute of Criminal Law and Criminal Justice at the University of Minnesota. So really glad to have you with us on the commission, so welcome. Nate, is there any way we can turn up the volume for the folks that are remote?
So Jill has contacted the Senate
Okay.
about that, and so they'll be over here.
Thank you. I forgot to bring my hearing aid today. Okay, so the next item on the agenda is approval of the agenda. So I will ask Nate, sorry, I'm not asking Nate anything. I'm looking for a motion to approve the agenda.
So moved.
Commissioner Schnell moves. Commissioner
Second.
Middlebrook seconds. Any discussion? Hearing none, I'll ask Nate to read the roll on that.
To the Schnell motion to approve the agenda, Estrada?
Yes.
Estrada, yes. Blakey?
Yes.
Blakey, yes. Hansi?
Yes.
Hansi, yes. Knudsen?
Yes.
Knudsen, yes. Ladd?
Yes.
Ladd, yes. Larkin?
Yes.
Larkin, yes. Middlebrook?
Yes.
Middlebrook, yes. Moore?
Yes.
Moore, yes. Morath?
Yes.
Morath, yes. Schnell?
Yes.
Schnell, yes. Chair Mitchell?
Yes.
Chair Mitchell, yes. Madam Chair, there are 11 votes in favor, no votes opposed.
And with that, the agenda is approved unanimously. The third item on the agenda is approval of the draft meeting minutes from December 16th, 2021. Those were sent out last week, so you should have all had a chance to review them. And I am looking for a motion to approve the minutes.
Motion to approve.
Commissioner Moore makes that motion. Do we have a second?
Second.
Commissioner Knudsen seconds. Any discussion on the minutes? Hearing none, we'll ask Director Wrights to read the roll.
To the Moore motion to approve the December meeting minutes, Estrada?
Yes.
Estrada, yes. Blakey?
Yes.
Blakey, yes. Hansi?
Yes.
Hansi, yes. Knudsen?
Yes.
Knudsen, yes. Ladd?
Yes.
Ladd, yes. Larkin?
Yes.
Larkin, yes. Middlebrook?
Yes.
Middlebrook, yes. Moore?
Yes.
Moore, yes. Morath?
Yes.
Morath, yes. Schnell?
Yes.
Schnell, yes. Chair Mitchell?
Yes.
Chair Mitchell, yes. Madam Chair, there are 11 votes in favor, no votes opposed.
And with that, the minutes from December 16th are approved unanimously. Item 4 on the agenda is review of the public hearing record. So this is for Director Wrights to take us through the record of the hearing that we had last month.
Thank you, Madam Chair. For the record, on Monday, November 15th, 2021, the notice of public hearing was published in the State Register, Volume 46, Number 20. On the same day, I should probably switch my video around. On the same day, the contents of the proposed modifications were posted on the Commission's website, and an email notice of the public hearing was sent to persons who have signed up on the Commission's website to receive informational emails. No one was notified by United States Mail because there are no longer members of the public on the United States mailing list. Pursuant to the notice, the public hearing was held on December 16th, 2021 in the Minnesota State Capitol Room G3 and by telephone and/or electronically. 29 members of the public wished to testify and did testify. After the public hearing, the record remained open for 5 calendar days through December 21st to accept written comments. From the beginning of the public hearing notice period through the end of the public comment period, the Commission received 3,600 pages of written comments from over 3,000 people. A list of those who spoke at the hearing, a link to the video and audio of the hearing, and copies of the written comments were provided to all Commission members on December 28th, 2021, and posted on the Commission's website shortly thereafter. The Commission appears to have complied with all public notice and hearing requirements permitted to take final action on the proposed modifications today.
Does that cover it?
That covers it.
All right, so then we'll move on to item number 5, accept or reject the proposal to amend the sentencing guidelines. Commissioner Schnell?
Madam Chair and members, after some considerable thought and in preparation for today's meeting, I put together some thoughts I'd like to share. In addition to being present at the December 16th public hearing, I've watched that hearing again, and I've reflected on the range of comments that we heard. I've also reviewed some of the discussions we as a commission have had on the topic of custody status point over the past many months. In my review of the hearing and the discussions had by this body, I must say I'm troubled by some of the comments we received. To be clear, I'm not bothered by the differences of opinion. Those differences are to be expected. I'm troubled by how, at least in part, the discussion has devolved into exactly what I believe this body was created to avoid. The use of rhetoric versus principled policymaking guided by thoughtful research. As the members know, we are not elected to these roles. The Commission is in fact a product of the Minnesota legislature, established to be one step removed from the legislative process. The Commission exists to keep these decisions grounded in data and research, not politics. In advance of the public hearing, our discussions benefited from research, analysis, and comprehensive data prepared by the professional staff of the Guidelines Commission. We reviewed and discussed a range of alternative proposals identified and supported by various members of the Commission. We heard well-reasoned arguments on both sides of the issue, leading up to a majority vote to send the proposal to a public hearing. The public hearing is an important part of our process, and I found the range of opinions both against and for elimination of the custody status point to be illuminating. But unfortunately, many of the comments were relevant to the policy question of custody status itself. Some, including sadly, members of this commission and even some members of the legislature, reported the inaccurate, misguided 1980s tough-on-crime rhetoric tactics that ushered in many of the ineffective and costly policies that did not, in fact, make us safer. The rhetoric drives fear, and these fear tactics impede thoughtful discussions, allowing the false choice of tough-on-crime or soft-on-crime to rule the day. The Commission exists to develop smart, fair, and balanced crime response policies. And as a state, we should use every tool to respond to and address crime, including the use of lengthy terms of incarceration where it's warranted. During the hearing, we were accused of acting outside our legal authority, which makes no sense, given that we exist only because of legislative action. The legislature created this ongoing policymaking body to develop and maintain a model for rational and consistent sentencing practices that promote public safety and reduce disparity in sentencing practices. The Commission studies these sentencing issues, develops and debates policy proposals, collects public input, and makes sentencing policy decisions that the legislature can elect to overturn or not. Policy positions aside, there should be no doubt in this instance the Commission did exactly what the legislature created us to do. During the hearing, another legislature accused at least some of us of doing the bidding of the governor. The fact is that the Sentencing Guidelines Commissioners appointed by Governor Walz came down on both sides of the vote to advance the elimination proposal to public comment. This reality demonstrates the independence of the commissioners appointed to this body. Through the course of our discussion of custody status and during the public hearing, it was implied that an opinion different from the status quo on this narrow and admittedly complex issue is a slight to crime victims. Assertions by certain legislators and even some members of the commission that a given policy position demonstrates a lack of care for victims is simply unfounded. I am confident that there's not a single member of this body who isn't concerned about the horror experienced by and the harm caused to crime victims. We heard some of that impact in the public hearing. But we also received a letter from one of the state crime victim coalitions taking a principled position in support of elimination. Several members of this commission are themselves victims of violent crime. Some are deeply knowledgeable about trauma and the long-lasting impact of criminal victimization. During my career, I've been at the scene of numerous violent crimes and comforted victims and families. I've listened to and consoled and encouraged victims during long investigations. And I've had to explain to victims when we as a system were not able to get the results they expected and deserved. Members, I'm heartbroken for the victims who testified about their very real and recent victimization experiences. I'm concerned that some of these victims of crimes were left with the impression that custody status point elimination is somehow the difference between an offender being held accountable or not. This is not the case. I'm troubled that some legislator testifiers appear to have taken advantage of victims' righteous anger to create confusion that elimination of custody status is the difference between justice or no justice. The true impact of custody status wasn't, and for the most part, the topic of our discussion on December 16th. We didn't give much attention to explicitly exploring how custody status point actually affects sentence length. With few exceptions, the impact of custody status on sentence length is quite limited for most people. The notion that maintaining the custody status is the difference between public safety or the lack thereof is absurd. The truth is that custody status point makes an average sentence only slightly longer, from weeks to a number of months in most cases. Belief that longer sentences yield increased public safety is contradicted by decades of research and data. We also heard numerous references to how this proposal prohibits judges from even considering previous offending when it comes to sentencing. Even if custody status elimination becomes policy, there are numerous other existing mechanisms to enhance a person's sentence. As members know, the sentencing guidelines currently provides aggravating factor enhancement, severe violent offense enhancement, and there is a specific carve-out for repeat sexual offenders, to name a few. Members, I remain in support of custody status point elimination because I believe it reflects what the Minnesota legislature directed the members of this body to do when the Guidelines Commission was established. That is, to develop and maintain a model for rational and consistent sentencing standards that promote public safety and reduce disparities. Accordingly, having a system that classifies sentence based on offense severity and criminal history is a rational model. And research has shown that sentence length itself does not yield better public safety outcomes. When I think about all the public input, whether people were for or against, whether grounded in principle argument or one of the thousands of solicited one-click emails, or the rhetoric of fear, it's clear to me that we, as members of this commission, have more work to do to help our fellow Minnesotans understand and consider the true implications of custody status. We haven't done that. I encourage all policymakers who are interested in improving the actual public safety outcomes in our state to use data and research versus fear-mongering tactics. Madam Chair and members, I want to conclude my comments by making the following motion. I want to move that action on the custody status point be withdrawn at this time for the commission to continue its study of the custody status point as a sentencing policy. And two, that the commission make concerted efforts to engage and educate community members, system stakeholders, and legislators as we further assess the implications of custody status point policy. And finally, to address the handling of the half-point issue, I further move that the commission issue guidance to criminal justice practitioners that aligns with the recent non-precedential Minnesota Court of Appeals case, State v. Eubanks, to direct that whenever a half-point is calculated, the half-point should be rounded down for the purposes of determining the criminal history score. Thank you, Madam Chair and members, for your indulgence.
All right, so we have a motion on the floor. Do we have a second?
Yeah.
Commissioner Estrada seconds. Discussion on the motion.
Well, Madam Chair,
Morath? Commissioner Morath, is who I call. Did you raise your hand? I did, but. Go ahead. No, go ahead. Go ahead.
As we've already opened, elephant in the room, I am new to the commission. And with that said, I have yet to participate or have my thoughts, on the matter shared. And given the weight that has been placed on the victim side of things and the thus far lack of victim representation, I'd be remiss if to pass on the opportunity to share a little bit of my thoughts today. And as Commissioner Schnell mentioned, the December public hearing was illuminating on all sides and on both sides. And again, consideration for the victim experience really stood out almost immediately as a central theme. And that was evident across testimony from both constituents as well as elected officials. And it truly goes without saying how difficult and impactful it is to hear just the first-hand victim accounts and the gravity of it. It's undeniable. And those who testified in person, that's only a fraction of the total voices. And we've thousands of written commentaries submitted, and it was similar themes are echoed and amplified across written commentary as well. And it's a lifelong sentence for victims. I'm punished every day for my assault. Victims are traumatized for life. Stand up for victims. We shouldn't have to live in fear. And again, as the victim representative, I couldn't agree more. In one statement, the public deserve to have representatives on this commission who have suffered at the hands of criminals who are repeat offenders. And I agree. And both fortunately and unfortunately, I am a victim representative on this commission who has suffered at the hands of a violent repeat offender. And I couldn't agree more and I couldn't care more. Just for a brief overview, I was in 2015 the victim of a violent repeat offender, serial rapist who was, by the time he was convicted, he was charged with 13 different separate charges. And so truly, I relate and I empathize with the victim testimony and commentary that has been shared on a very visceral level. I know what it's like to know that that when you're in that moment, that it is not the first or last that an offender is going to be committing a violent crime. I know that feeling, and I know what it's like to know that without even knowing the identity. I know what it's like to feel dismantled in the wake of an attack, to be left feeling robbed of identity, confidence, and voice, and then to feel like you're then further betrayed when the very individuals and institutions that you'd always held in such esteem and always placed so much trust, to feel let down when they demonstrate, whether it's a lack of capacity or compassion, to actually provide the critical support in times of need. And I also know what it's like to feel powerless in the realm of policymaking. I've sat in these very rooms in the past, and I've felt what it feels like to feel like just a passive observer watching government officials play politics with the most devastating and abject trauma of your life. I know what that feels like. And it's also why I'm so invested in doing victims, serving victims in this role. I understand. And it's why I've gone, I want to make sure that, I hope all victims who have been following this issue understand that, their voices are being heard. I can at least guarantee by one person on this commission, and that matters so much to me and is truly at the heart of my motivation and my energy to really understand this issue and to give it the justice that it deserves. And part of that, a big part of that needs to be having victim voices, those who are impacted potentially, having their voices considered in the decision-making process. But to arrive at the right decision, though, the experiential side of victimization alone must not outweigh or contradict relevant crime data and research that we have, because it's not, the right decision needs to be the one that gives equal weight to both the humanity of crimes, but it must also be effective in terms of public safety and protection against victimization, which leads to, again, some of the points that Commissioner Schnell raised on looking at the data. And I think there's been also a lot of just assumptions, overt or not, about what victims want. And preface that by saying there is no singular victim, there's no singular voice. But if you look more at the data and on surveys that have been conducted, it's pretty overwhelming across studies that there's a strong majority of victims who do not prefer longer prison sentences. They, in general, prefer more of a focus on rehabilitation. 3-to-1, victims prefer holding people accountable through options beyond prison. 6 in 10 victims prefer shorter prison sentences and more spending on prevention. And I don't want to get too bogged down in the statistics, but I just wanted to address that general assumption that all victims want the longest prison sentence as the top priority, because it's clear that it's not the case. But specific to the custody status point issue at hand, we've been given different data reports and summaries, and one of the key statistics that has been presented has in support of repealing the custody status point has been that it only helps to identify an additional 1 out of 100 recidivists, and that the criminal history scale is also less effective at targeting offenders most at risk for a serious violent offense. And this is in the different heat maps and whatnot. I think it's hard to argue with that, with those reports, and it doesn't lend much. I'm trying to be careful. Essentially, what the data seems to be indicating seems to be drastically different from the narratives that are being formulated. And there's been a great amount of weight put on sex offenses in particular. And I guess I'm a bit confused as to how we got here. With only 4% of all custody status offenders being sex offenders. And moreover, the vast majority of these violations are the lowest level severity, primarily due to failure to register. And I don't understand. If our goal is to increase public safety, I think that's a conversation that needs to be had, because the two don't. The custody status point does not seem to be effective in that regard, and not that I don't recognize the significance. I guess to not take up too much time, I'm going to skip some of the, again, getting too bogged down in the statistics and whatnot, and I just want to say in general, I guess I'm just very disappointed. I'm very disappointed that we have arrived at such what seems to be a very black and white option to be voting on, when this issue seems to be just inherently riddled with gray area, and there's truth on both sides, and there's as well as shortcomings that ought to be addressed. But it just seems that rather than productive collaborative conversations, the custody status point issue has been discussed more so in terms of thought terminating cliches and fear mongering and whatnot, and as a victim, that is personally and deeply offensive to me. It feels more as though when the data and research is being withheld or skewed and focused solely on the emotive side of victimization, that to me is not honoring or protecting victims, it is exploiting. And it's, as many victims have stated, they're living in fear. And I don't know what's worse than living in fear than also living in fear while also living in the dark. And I think I'm not advocating for creating public policy that only considers the raw data, and because there are so many things, so many aspects of victimization that cannot be quantified into reduced into quantifiable values and placed in some algorithm, and that really takes away from the totality of the human experience and the humanity of it. But there has to be a balance if we want to truly come to the right decision and the decision that will optimize and increase public safety. It can't be an either or discussion as it has been as I've perceived at least to this point. It has to be a balance between the research and data, the utility and efficacy, as well as the humanity and accountability that cannot be found in the tables and of the research.
Thank you, Commissioner Morath, for those comments. Appreciate it. I think somebody else wanted to make a comment as well. Judge Knutson, was that you?
Yes, Madam Chair. I think we're getting that. Hopefully we will continue to enjoy a robust and less black and white discussion of this issue based on the comments. I'm getting a lot of feedback somewhere. Are other people hearing that?
We're not hearing anything on our end.
Okay. I appreciate Commissioner Schnell's motion. I don't necessarily agree with his summarization of some of the comments because on one side, we're being painted a picture that almost every offender is being committed to prison and that these sentences are extremely and unduly harsh. What we need to remember, and we keep coming back to, is Minnesota is one of the lowest, has the lowest percentage of incarcerated offenders in the nation, and has been and has a tradition of that. You know, I served many years on the Judiciary and Crime Prevention Committees in the Senate. We didn't have these kind of partisan us versus them discussions. When you have clear Republicans and clear Democrats, it was almost always judicial policy, criminal justice policy was nonpartisan. We didn't have these kinds of disputes and the arguments that this commission has teed up for the legislature. And I'm very disappointed by it. And I agree with comments of Commissioner Schnell and others that we shouldn't have been in this position. And that's what's truly disappointing. But with the vast majority of offenders in this state are placed on probation, there's a time when rehabilitation and all those efforts and all that money fails. And then what do? We talk about, and our goal as a guidelines commission is to provide an equitable and fair guideline in sentencing, so it's roughly similar for the same offenses across the state. So it's not true upon the elimination of the custody status point, because when someone is placed on probation, they should be treated, and they commit a new offense, they should be treated differently than somebody that simply committed the offense. They are more culpable, they're more blameworthy, and we owe it to society to hold them more accountable. We didn't really get into the analysis of where those so-called harsh penalties are being imposed as a result of the custody status. That's something we could spend time on. There was discussions about other possibilities, but unfortunately we ran out of time and we were, I think, trapped or forced into accepting maybe one solution, and that's the elimination of the custody status point. And I just can't go there, and I hope the commission will keep an open mind about other options to solve this half-point custody status point issue. But it seems to me that the custody status point is simply a basic principle of sentencing to hold an offender more accountable who has committed a violation of the law while on probation. So again, I just want to thank Commissioner Schnell for this motion. And I think the commission can do a lot better given some more time and the members coming together to work jointly on a solution here. Thank you.
Commissioner Larkin.
Thank you, Madam Chair. I also appreciate Commissioner Schnell's motion that we take no action on this important issue and continue to study it and come up with a better resolution. However, I share Commissioner Knutsen's concern about some of the comments that Commissioner Schnell made. And I disagree with the picture he's painted of the comments and our circumstances today. I have opposed and continue to oppose complete elimination of Minnesota's use of a custody status point at sentencing because that proposal will reduce sentences for offenders. And I think that's a bad proposal for 3 reasons. The first is it's not consistent with public safety. The second is it does not have community support. And the third is that it sweeps too broadly. We're required to hold a public hearing if we recommend a change in criminal history score calculation or something that would reduce sentences. And at that public hearing, we have to allow the public an opportunity to submit written comments, oral comments, to ask us questions. In other words, we're accountable to the public. And I have to assume that those procedures and those requirements are put into place so that we listen to the public. As the executive director has reported, we received around 3,600 comments. I went through and counted. I came up with about a 94% group of comments opposing elimination of criminal or custody status point. And those comments were from victims, from county attorneys, from law enforcement officer stakeholders. I'm sure Commissioner Schnell did not intend this, but I am concerned that someone listening to his comments might think they're dismissive or condensating in that they don't appreciate what the public sees and what the public is feeling, which was reflected in those comments. And I'm also concerned about the suggestion that somehow we should discount comments that came in the form of one-click submissions. And I don't understand why we would criticize the public for taking the time, even if it is through some simple mechanism of communicating its comments to the commission, why we criticize them for doing that when we're supposed to have a public hearing and listen to the public and their views on our proposals. I note that a lot of those one-click comments did have additional written comments on the submission, and I think all of those comments are important, and I don't think we should dismiss any of them simply because they're not the view that we might want. And I feel like that was the tone of the comments, and that's an inappropriate position for this body to take or to allow anyone to think we're taking. The reality is that it cannot be disputed that violent crime is at record highs. We have news stories every day regarding violent offenses committed by offenders who are on probation. There's a perception that the criminal justice system has a revolving door and it doesn't hold offenders accountable. Seasoned prosecutors are resigning. The public submitted extensive comments complaining that offenders are not held accountable for their crimes and that failure to do so has led to more violent crimes and has put the public at risk of harms. I mean, the public comments opposing the proposal consistently criticize the resulting reduction of presumptive sentences for repeat offenders as illogical and lacking common sense. Now, Commissioner Schnell says, well, obviously the public doesn't understand that we have statistics, we have data, we have research that says none of this will impact public safety. And I just have to say that I've been asking as a commissioner, where is it? Where is the data or the research or the statistics that says we have in place in Minnesota programs that will prevent people from reoffending and prevent people from harming others that can take the place of incarceration if we're going to reduce incarceration for repeat offenders. Where is the data? What is the program? I don't fault the public for thinking, well, whatever programs we have in place now obviously are not working because people keep reoffending. They get arrested for violent crimes, they're released, they reoffend shortly thereafter. They're supposed to go to prison for presumptive commitment offense. They get a downward dispositional departure. They reoffend. They hurt someone else. So I think there's a disconnect there. People keep talking about the research, the data, the programs that are going to rehabilitate and avoid the need for incarceration, but I haven't seen them. And I think that's the frustration we're hearing from the public. And we shouldn't dismiss that and say, well, trust us, we've got the data. You just don't know the data. So I think that's a bad message to send to the public. I mean, my statements are based on years of experience in the criminal justice system. And as Judge Knutson, Commissioner Knutson said, I can tell you as somebody who was a public defender for 13 years in Hennepin County, it is not easy to get sent to prison. People get an opportunity on probation. People get multiple probation violations. People get more opportunities. Judges don't revoke people and send them to prison for technical violations. That's a narrative on one side. That's false. Judges are required to follow the Austin factors, which require judges to continue to use efforts to keep people in the community and rehabilitate them until an offender has demonstrated clearly that the policies that favor probation are outweighed by the need for incarceration. So again, I just don't want people who are watching this hearing who have invested time and effort into impacting this board's consideration or this commission's consideration of the issue to, tune out thinking, well, we've just been dismissed. Our voices don't matter. We've just been told we're not smart enough to understand the data. Therefore, we shouldn't be concerned about the latest carjacking on our block. That's not fair to the public, and we're obligated to listen to the public. I support the notion that we should work cooperatively to come up with a solution. The solution that was put forward to a public hearing over the objection of several commissioners is one that comes at a very technical, limited problem with a sword and not a scalpel. This body passed a rule that allowed for criminal history scores to end in a half point, not realizing that the guidelines don't discuss that. We spent, as a work group, a year discussing other proposals. I was on that work group. Things were suggested like, well, let's not have a custody point. Let's do a 10% enhancement or a 15% enhancement. Let's look at a rule that says you don't get a custody point unless you have so many prior convictions to begin with. I mean, we were looking at all of these things. And in the end, what went to the commission was sort of all or nothing. Let's change the grids to accommodate this point, or let's get rid of the point altogether. That wasn't the direction or the path we started on, but somehow it's where we ended up. And I agree that we do need to look, as Commissioner Schnell says, how sentences will be impacted. Because one of the concerns I raised on the work group is every time we came up with a proposal that sounded good in theory, when I looked at the grids and ran some examples to see what the impact on actual sentences would be, I was finding significant reductions in sentences. And that concerned me because I didn't think that was the direction we wanted to go. So we have to look at those numbers. We have to see how these proposals play out. I mean, for example, if someone with no criminal history commits a simple robbery, the presumptive sentence is 18 months on probation. If that offender, while on probation, commits an aggravated robbery, the presumptive sentence now would be 12 months longer than if we eliminated his criminal history point. In other words, if we sentence him with a criminal history point, he faces 12 additional months than he would if we don't sentence him with a criminal history point. So although there are examples at the low end of the grid where this custody point doesn't make much of a difference, when it comes to more serious offenses, it does make a difference in the length of sentence. And not only does it make a difference in the length of sentence, it makes a difference in terms of whether or not someone actually gets sent to prison. Because there's a line you cross where you go from probation to prison. When you're at the low end of the grid on low-level offenses, you don't cross that line unless you have 6 criminal history points. 6 criminal history points before you get sent to prison. Now, for more serious offenses, 1 or 2 criminal history points or no criminal history points will get you there. But we need to look at all of these things. And that's why I'm disappointed that what was pushed in the end was, well, let's just eliminate the custody point for everyone. And I'm not surprised that that approach did not resonate with the public. And I'm not surprised by the backlash this commission received. And I know there are views on both sides, and I don't think either side's views should be discounted, much less by citing, data and research without pointing to a program in Minnesota that is going to allow people to feel safe in their communities, safe in their school parking lots, safe in their shopping center parking lots, and, heaven forbid, safe in their home. We owe the public more. And I, for one, am glad that the public spoke up and is holding this body to its obligation to ensure public safety.
Commissioner Estrada.
I appreciate everyone's comments, and I appreciate Commissioner Schnell for the proposal. I personally did not take his comments to mean that we were dismissing or this commission was dismissing the comments of the public by any means. What I took away from that is that there is a lot to learn and that there is a lot to discuss, and the guidelines are complex. The guidelines are complicated. They're complicated for practitioners who do it every single day. And likewise for people who may not work in the field, they're just as complicated. I think that when I heard Commissioner Schnell's comments, it was more in terms of how do we provide all of the information so that when we are presenting this, that it's a well-informed decision, and it's kind of to Commissioner Morath's comments, we're giving equal weight to, or not equal, but we're giving weight and seeing that the same 2 sides to both victim safety as well as data and research and what works. I'm a bit offended, Commissioner Larkin, that you continue to bring up that data or sources have not been cited. There was a commission meeting where I specifically gave you name of researchers about dosage programming, dosage probation, how many hours of programming a high-risk client may need to reduce the recidivism, the data that shows how much recidivism is decreased based on that dosage programming. And yet I never received a follow-up call about some of that information if you were further interested in learning about it. But I did cite some of that. I also want to point out that recidivism occurs, and we have this data too. I believe it was when we were looking at probation lengths. Recidivism occurs within the first 7 months. The data we also have shows that the majority of the people that are getting a custody status point are low-level offenses, property and drug offenses. So I'm not surprised. And even, I believe it was a county attorney, I can't remember what county it was at the public hearing, also testified that the ones that are recidivating is not violent offenses. It's not the severe offenses. And to your point in the example that you gave in terms of the person who has a first-degree aggravated robbery, and then the second one getting not having a custody status point, having 12 months less, we cannot forget the fact that the first degree aggravated robbery is on the severe violent offender list, which increases sentencing by 12, 18, and 24 months. So even without the custody status point, that individual that you gave the example to would still get an additional 12 months. And I think to Commissioner Schnell's points, it's being able to highlight what is already in our toolbox. It's what is in the guidelines that allow us to address the concerns. Because yeah, I'm not going to sit here and say, you know, none of our violent offenders are reoffending. That's not the case. We know that that's not the case, but we also know that that's not the majority. And so there are things within our guidelines that allow for harsher sentences for the targeted population that we're really trying to protect victims from. So I think that Commissioner Snell's point and his comments, I respect them and I agree with them. And I think that it's clear that we continue to need to not just not educate, but inform and do a better job of bringing out information, not just for the public, but for our own commissioners as well. And I do still stand by the fact that the data shows, and coming from the probation side, and I can appreciate Commissioner Knudsen's comments about this isn't everybody who's going to prison, but I'm happy to have conversations about how it impacts people that are on supervision too. And you know, and I think Commissioner Morath brings, you know, a lot of experience and knowledge as well. And some good insight that can help have further conversation.
Commissioner Hansi and then Commissioner Schnell.
I just want to reiterate a little bit of what Commissioner Estrada is saying, as well as Commissioner Schnell. This bringing about, what was most heartbreaking to me about this is that at the public hearing and throughout all the letters, a lot of misinformation. So a lot of the public was misinformed that this was releasing people with sex offenses, and that just it felt like a lot of hysteria that was being pushed through to people, and that those were not even, that was not factual. It didn't include those people. It doesn't include those offenses. It just doesn't. And so there was a lot of misinformation that was sent out to the public that it was heartbreaking, because those people have to live with that fear, and it's just continuously trauma triggering people, especially, you know, those who have experienced violent crimes. And, you know, just because I don't sit as the person, the victim in the victim's seat here, it does not mean that I also have not experienced, and I've said this to the commission as well. I've also been, I also am the survivor of a violent crime. And I also know that longer sentences are not helping. You know, when it's pushback, we don't have data. Well, if we look nationally, since the 90s, when we're talking about when it was, you know, we need law and order, like we heard Senator Limmer say over and over again at that public hearing, we need law and order, we need law and order. That was the 90s. And have we seen a crime diminish since we've gotten tough on crime? No, we haven't. It's actually gotten to be, the numbers are the opposite from that. More people are locked up for longer periods, especially, you know, when we look at women, especially, it's been since 1986, it's went up 832%. Those old ways have not been working at all. And when we talk about not having, what programs are we using? Well, it's hard to know, because none of the funding is going towards those programs. Instead, we're continuously putting funding towards locking people up longer. And so there isn't any community investment into programs. So I just, you know, this was a very telling experience, and also very disappointing to just understand that the misinformation that was given to the public about what this actually even meant. So thank you.
Commissioner Schnell and then Commissioner Moore.
Thank you, Madam Chair, members. I felt the need to address, I think, a little bit the fact that, what was characterized as somehow my point was that members of the public aren't smart enough, I think was the notion that Commissioner Larkin attributed to me. And I don't think that that's reflected in even the motion. The reality is, as I said, that this is complex policy. It is challenging. And I also indicated that there is a place for very, very lengthy sentences. There are people who belong in prison for a long time, perhaps ever. Nobody is disputing that. That's not the issue or question at the table, in my understanding. We're really talking about the issue of custody point status. That difference, what tools are available as a tool. And I just want to come back to that. And I hope that we can get to a point where we don't try to put words in each other's mouths necessarily, and get to this point of saying, how do we find that balance and the right response in recognizing that there may be differences of opinion. But to the extent that we can ground that, those differences in the places where we really truly understand the impact of custody status as it relates to public safety, that's the part that I think I'm concerned that the difference between public safety and the lack of it is grounded in custody status. And the evidence for that simply isn't here. So I just want to clarify if I somehow conveyed that. I don't know. That was certainly not in my words. I looked in the text, and it was not. Never said that people don't understand this. I think that what became clear is the need for us to engage in broader conversations with interested members of the community who are focused on and do want, and we all should want, increased levels of true public safety. And that is the goal. And that's what I'm hoping can come of another year of study. The last thing I would just say, I hope as we do talk more about sentencing, that we do spend some time, not just talking about this, but also talking about what is effective, what does work. Ultimately, at the end of the day, we know that the 7,500 people in prison today, out of that group, 95% are going to be coming to communities across our state. And I agree 100% that we want them to come back better than they were when they went in, so that we don't have repeat offending. Will we be 100% successful? No. The only way we can do that is we sentence everybody and we hold them there based on what they might do, which this country doesn't do, as you know, even better than I. So ultimately, what I'm advocating for is taking the time to step back, to have more conversations, to engage all members of the community, system stakeholders, to ultimately further study this issue, and hopefully truly ground the question not in what's happening in our community, which we're all disturbed by. I'm as disturbed by it as anybody. If you're involved in carjacking and that's a robbery, that's a commit offense, and that's where that's what should be happening. There's no dispute about that. That's not the custody status question, in my view, especially when you look at where impact is at, and that's really what I hope we can really get around and engage others in that discussion. Thank you.
Commissioner Moore and then Commissioner Middlebrook.
Thank you, Madam Chair. I speak in favor of Commissioner Schnell's motion. I think the public deserves a robust and thorough discussion of this issue. And this is too important to be, frankly, rammed through with any timeline in mind here, given what we heard at the public hearing and given the comments of the other members of this commission. Commissioner Morath is correct. This should not be a all or nothing proposition, and unfortunately, that's what it's turned into. And it's really disappointing that we're here because the issue that we're trying to fix is an issue that was created by this commission in a good faith and considered effort to try to address the impact of custody status in the criminal justice system. And he created the half-point custody status point and gave judges the authority in certain circumstances, or the ability, I should say, to waive it if it was in the interest of public safety. And unfortunately, a technical problem with regard to the way that the half point doesn't correlate to the grid arose. And so we started to try to fix that, and somehow we got to the point where all custody status points were going to go out the door, which is grossly overbroad and an unreasonable response to the issue at hand here. I've been a lawyer for 33 years, and I've been in the criminal justice system for 27 of those years, 25 in the front lines, frankly, in a small outstate county, Nobles County, as a county attorney and as a district court judge. And almost every day during that experience, I worked with police officers, probation agents, crime victims, witnesses, judges, and others in the criminal justice system trying to make it better for everybody. I'm going to push back on this notion that my colleagues in the district court are reflexively sentencing people to prison for technical violations while on probation. That just is not the case. Judges are giving offenders the opportunity in appropriate circumstances for treatment court. They're being given the opportunity for probation, as Judge Larkin indicated, sometimes departures from presumptive sentences, in an effort to try to focus on rehabilitation where that's in the interest of public safety and where it's appropriate. I think it's critical for this body to remember that this isn't just an academic exercise we engage in here. The legislature established this commission for the purpose of us considering particular items in regard to sentencing guidelines. And the primary consideration of the commission, according to the legislature, and I'm quoting, shall be public safety. The commission is also tasked with considering sentencing and release practices, correctional resources, including but not limited to the capabilities of state and local correctional facilities, and I'm quoting again, the long-term negative impact of crime on the community. In other words, this isn't just an academic discussion. This isn't just an analysis of statistics and journals. This is a focus on what's actually happening in our communities. And it was pretty evident to anybody who listened to the public hearing what the sentiment is that we heard. Judge Larkin explained the breakdown in the comments, and they were compelling. It's important for people to remember that since at least 2015 and probably years and years before that, it's the policy of the judicial branch to impose standard probationary conditions on offenders that are being sentenced for violent crimes. And one of the standard probation conditions is that offenders are ordered by the court to follow all state and federal criminal laws. It's just a fundamental requirement of probation. And so it seems to me that a more severe sanction for offenders who commit a new felony offense while on probation, notwithstanding an express directive from a judge that the offender must not commit any crime while on probation, reflects a reasoned determination that the offender's new crime is a more flagrant violation of the criminal laws and does make the offender more culpable. Now, the fact that the original sentencing guidelines didn't necessarily articulate what was characterized in the report as a robust rationale for the adoption of the custody status point 41 years ago is something that I think could be probably explained by the fact that the rationale for it is pretty obvious. If two people commit the same crime and only one of them is on probation and expected to demonstrate that incarceration for the unexpired prior conviction is unnecessary, then that offender had more incentive to remain law-abiding and is obviously more blameworthy than the other offender. Now, notwithstanding that, I think the discussion that occurred in 2018 regarding the custody status point in its effect, particularly on lower level offenses, is a needed discussion. And I'm confident that my colleagues, like Judge Knudsen and others in the district court, have the experience and the understanding of offenders that appear before them to know when and where to apply the tools that have been given. We just need to fix this half-point issue. Pulling this back into a committee where we can get together, hopefully talk about this in a profound way, I think serves the public, and that's what we're here to do today. As Commissioner Schell noted, the Court of Appeals has spoken in at least 3 cases related to the question of rounding. Those cases, to my knowledge, are not being appealed. That suggests to me that, at least for the time being, we don't have an emerging crisis in the courts on this that needs to be remedied by a drastic and overbroad solution. It is an issue, however, that does need to be addressed. This has been hanging around too long, and we owe it to the practitioners, the judges, the probation agents, to have clear directives. And so Commissioner Schnell's suggestion that we give some guidance to the parties in our justice partner arena in the district courts, I think is totally appropriate. So, Madam Chair, it's for those reasons that I will support Commissioner Schell's motion to withdraw this proposal and continue studying it appropriately. Thank you.
Thank you. Commissioner Middlebrook.
Thank you, Madam Chair. I do appreciate the comments of all the commissioners, particularly Commissioner Schnell, and your comments. I do feel like some of them were taken out of context and taken the wrong way by some other commissioner members. I also would note that, contrary to Commissioner Larkin's comments, I think all of us took into consideration all the public comments. We spent hours listening to that testimony. We also, I think all of us spent hours, if not days and days, reviewing all of those written comments that came in. And I think so we all are very aware of all of those on both sides and appreciate all of that input. I do support removing the custody status point from the criminal history score. I see custody status that it does not measure criminal history, and it doesn't increase the severity of the crime that's committed. I also don't see that it increases the culpability necessarily of the person either. What it does is it adds punishment. And in that respect, it doubles or triples the punishment for the offender for that offense that they're on custody status for. And we've heard a lot about where's the research, where's the data. We do have research, we do have studies, we do have data that show that the custody status affects mostly low-level drug and property offenders, which many of them are due to addiction. And I think that's something that we can look at closer and probably look at exactly what crimes are being affected the most and the sentences that are being affected the most. It's also very clear that the custody status in the criminal history score is one of those policies that has been around since the beginning of the guidelines. And just because something's always been done a certain way doesn't mean it should continue. It's one of those policies that does increase the racial disparities of who's going to prison. And I think that that's one of our tasks, is to look at that and try to make things more fair and to reduce those disparities. Like Commissioner Snell noted, none of us are ignoring the current increase in the crime or the victims of offenses. We're all very aware of that and concerned about that. I think there was a couple of testifiers who made a really good point. Right now, this current crime wave is going on, and our current guidelines with the custody status point is part of those guidelines. So equating the current situation with the policy to do something different with custody status doesn't even follow. So I guess all that said, it's very apparent from reviewing all of the comments from the public hearing and hearing the testimony and hearing from other commissioners commission members, that we need to continue working on this policy. And as much as I would like to vote on it today, I think that we do need to continue the study, continue the discussions, hopefully all work together on this, and also educate the public and all of the stakeholders involved about why this maybe policy does need to be changed. Thank you.
All right, thank you. I'd like to also say a couple of words. I also continue to support the policy to eliminate custody status. I've said this from the beginning. I still believe it now, that culpability is something that's different in every case. And as Commissioner Middlebrook explained, you know, for some people, repeat offending is driven by addiction. And I don't think that there should be increased punishment in those cases. For other people, repeat offending is driven by criminogenic factors, that they just are more likely to reoffend, and we haven't been able to change that path for them and intervene. And maybe in some of those situations, individuals are more culpable and deserve more punishment. But what we have right now is a policy that applies across the board to everybody and doesn't take that into consideration, doesn't take any of those individualized considerations into account. Eliminating custody status would allow the judges to take that into consideration where it's necessary. It would allow prosecutors to use the tools that we have on the books within the guidelines. We have multiple tools on the books. We also have laws on the books that address reoffending. It would allow all of those tools to be brought to bear in appropriate cases, and it would not increase punishment in the cases where it's not merited. So for that reason, I would love to be able to vote for the custody status repeal today. But I also understand that the public isn't with us right now, and our stakeholders aren't with us right now, because there is a lack of understanding about the ramifications of this issue. There's a lack of understanding about the underlying data. There is a narrative that is taking place that is referring to offenders that in many cases aren't even affected by these policies. And so I do want the commission to continue the discussions. This will be on the agenda in the future. We will continue this discussion alongside our other work. And I really hope that the media that's here today to hear this decision today will continue to cover this issue and help us educate the public and our stakeholders about what this policy really means and the conclusions that we are able to reach down the road as to where we should go with it. I hope that interest continues because this is not an issue that's going to go away. I do need to correct the record. Earlier today, there was a press conference at which Senator Limmer stated that if we pass this policy today, that 536 prisoners would be released immediately. And that is just false. And it's the type of statement that creates fear within our community. It's very disappointing to me that as the chair of the Senate Judiciary, Senator Limmer is unfamiliar with how our bed projections work, that he failed to recognize that any changes that we make would be prospective only, representing prison beds that would be avoided in the future, and that, in fact, it would take 16 years for the cumulative effect of sentencing. Small changes in sentence length applied to thousands of individuals over time to result in that level of bed savings. But that's not what was said today. And that does disappoint me. That's the kind of narrative that we cannot continue to have placed out in the public. We need to have facts, and we need to be talking about these things logically. We need to also recognize the emotion. But our job as a commission is to understand, is to really look at the actual implications of policy. That's why we were created, to track how actual sentencing occurs to understand the impact of that on our criminal justice system, on our communities, and to create policies that make sense, that are effective, that are cost-effective, and that work. That's what we're here for. We're here because we have a level of expertise, and we have the time to talk about these issues in a way that the legislature does not. We don't have to slam things through a hearing to get to the end of the session. That's why we're actually taking the time right now to not vote on this today, because this is what we do. We actually do spend the time to figure these policies out and try to get it right. And I might add, we don't do this in a vacuum. Once we're done with our work, we send it to the legislature, and it's their job to review it. And we understand that, and we respect that process. That's a check and balance that was created by the legislature 40 years ago, and we have always respected that check and balance here at the commission. And we will continue to do that. So this will be on the agenda. We will move it forward. We will continue to talk about it. We will develop the policy that we think is the best decision for the state of Minnesota. And then when we are done, we will send it to a public hearing again. We will hear the input of the public again. And then we will send that final decision to the legislature for their review, which is how it has always been and how it will continue to be. And with that, I would like to go ahead and take the roll in this vote.
To the Schnell motion to withdraw action on the custody status point issue at this time in order for the commission to continue its study of the custody status point as a sentencing policy, to make concerted efforts to engage and educate community members, system stakeholders, and legislators as the commission further assesses the implications of the custody status point policy, and to issue guidance to criminal justice practitioners that aligns with the Eubanks non-precedential Court of Appeals decision to direct that whenever a half point is calculated, and I assume that's a half custody status point is calculated, the half custody status point shall be rounded down for purposes of determining the criminal history score. And before I take the roll, Commissioner Schnell, can you confirm that that reference to half point was a reference to a half custody status point?
Yes, it was. Thank you.
So to that Schnell motion, Estrada?
Yes.
Estrada, yes. Blakey?
Yes.
Blakey, yes. Hansi?
Yes.
Hansi, yes. Knutson?
Yes.
Knutson, yes. Ladd?
Yes.
Ladd, yes. Larkin?
Yes.
Larkin, yes. Middlebrook?
Yes.
Middlebrook, yes. Moore?
Yes.
Moore, yes. Morath?
Yes.
Morath, yes. Schnell?
Yes.
Schnell, yes. Chair Mitchell?
Yes.
Chair Mitchell, yes. Madam Chair, there are 11 votes in favor, no votes opposed.
And with that, the motion is approved unanimously. All right, we'll move on to item number 6, which is to review and approve the 2022 report to the legislature. Do we actually, before we move on to that, we gave direction, with that motion, we gave direction to send notice out that the half points should be rounded down. But I think that we should spend a moment talking about the logistics of that. Mm-hmm. Last year, when we asked you to give direction to the community, we asked you to send a message out. And I would assume that at a minimum, we could do a communication along those lines. I'm also wondering what options could potentially be for the sentencing worksheet itself so that this is somewhat clear to the court system.
Thank you, Madam Chair. May I respond to that?
Yes, please do.
Okay,
Dr.
so
Rice.
take it as implied by the motion that we should write up a memorandum explaining that. We have a web page right now, and we should put that out. But also, it would be my intent to contact the custodians of the electronic worksheet, which are Commissioner Schnell's very able IT staff, and ask them to make a change to the calculation of the electronic worksheet to be consistent with the Eubanks provision. So effectively, although somebody with a half custody status point would still display half custody status, the total sum would now essentially eliminate custody status in the calculation of the criminal history score if that custody status was only 1/2 point.
So the system would round it down for
right.
the core, okay.
Right, so the system would round it down consistent with the Eubanks opinion.
Okay. I just wanted to clarify. I do think that's consistent with what we just asked for, to have a memorandum drafted and sent out. And then that sounds fine to me, to have the system follow the guidance that we just gave you. Does anyone have any questions or comments before we move on?
I have just one thing to add to that, Madam Chair, and that is, it is a process. In fact, this morning just had the quarterly decision-making meeting on what items are going to be changed in the corrections portal altogether, not just the electronic worksheet system component of that. So it may take a frustratingly long amount of time. However, I will say that the good folks at DOC have been extremely accommodating to the needs of the electronic worksheet system. They do understand that it impacts sentences, tens of thousands of sentences every year, so, or more than 10,000 sentences every year. So they do give it a priority.
Okay, Commissioner Moore?
Thank you, Madam Chair. Madam Chair, I think it's important that this guidance be labeled as interim guidance, just so it's clear that this is sort of to preserve the status quo, but doesn't imply that a final decision has been made on this. Obviously, we're going to be studying this robustly, and so hopefully the practitioners will understand that this is a kind of a temporary solution to try to give guidance during this time.
I think that is fair, and so Director Wrights, please, if you could work that into the memo, that would be helpful. I feel like I saw someone else's hand and I might have missed who it was. No? Okay, all right. Anything else you need from us on that then? Is that good? Director Wrights?
I'm looking over at my senior research analysis specialist to see if she has anything, but no, that's all I can think of.
Okay. Sounds great. Okay, great. Then the next item of business is the legislative report, which is due for Saturday.
It's due Saturday. I have plans, so I'm really hoping to get it out tomorrow. So, yes. All right, so I'm going to share the screen. I think that'll work. All right, so the document that I'm showing you now is the document this is the January 6th staff draft. We've made some changes. There is a draft that's a little bit more recent than this. Those changes were to a section that I'm going to propose be deleted and to update the county attorney report section. But frankly, that could change between now and tomorrow morning. So, because there's still 4 counties out, but not to give away anything. So the highlighting here,
I don't think you're showing on the screen yet.
I didn't press the share button, I'm
Yeah.
sorry. And that's not the first time I've done that. All right.
There we go. That's helpful.
So
We're getting there.
let's see, that didn't work.
No, I can see it now.
Yeah,
well,
but
I
it's
can
not
see
showing
it
up on
here.
Oh, I need to move it over to this. Okay. I need to do it differently so that it shows up in the room as well.
Okay.
So I'm going to share this screen and then drag it over. Okay. So the what's highlighted in this blue cyan color are things that we're anticipating will be changed, and yellow is something that's different from the December report. I'm going to go through this pretty quickly. Okay, so as far as the table of contents goes, we have appendix, we have four appendices right now. So, the first two are things that are required by law to be reported in the report to the legislature. All guidelines modifications that took place in the preceding 12 months, that's in Appendix 1. And then Appendix 2 is proposed guidelines modifications. So this is the only proposed guidelines modification, the modification that did not pass a few minutes ago. So Appendix 2 is simply going to be deleted, just so that's clear. And obviously, if there's anything I'm saying that somebody has an objection to, please speak up. So there were some just wording modifications, just basically to break out those two requirements from each other. So I put them into separate bullets. In the executive summary, we would be deleting. We'd be putting an "and" before the word "developing" here on the second bullet, and then deleting the fourth bullet, if that makes sense. So pretty much deleting what's in cyan here. Continuing on in the executive summary, this number on the county attorney's firearms report, that 1016 will be updated. I'll talk a little bit about the changes to the sentencing practices data summary when I get to that, but we are making some changes to how we're presenting the data due to some issues we're having, and I'll talk about that shortly. All right, so the first section is the Commission's work in 2021. The first page of that, we pretty much do a roll call of who's on the Commission and people that changed over the year. For some reason, I neglected to include the bit about Commander Omari. He was here in January, so he was in the last report to the legislature, and I forgot to include his resignation and his replacement by Officer Blakey. My fault. So no changes here to the to this. I'll probably reword the sentence. I think it's important to note that the discussion of the half-point issue led to a proposal to repeal the custody status point policy, but it ultimately was not successful. So, I mean, if you don't mind just kind of giving me some editorial leeway to wordsmith that, this would be pretty brief.
Commissioner Middlebrook?
Thank you, Madam Chair. Director Wrights, I guess I would suggest that you include what you just said about the sentence, but also adding in both on page 6 and here that the Commission will continue to study this in 2022. I think
Sure.
It should be added into those places that there's going to be rather than it just didn't go anywhere, it was withdrawn, that we're going to continue to study it.
Yeah, I mean, in page 6, I did try to keep the executive summary down to one page because it is an executive summary, but yeah, I think we could put that in there because we do have a bullet space, so I think we could still fit it on one page.
Yeah.
And talk about the continued work on that bullet on the executive summary.
Okay.
Okay, sounds good. And we could spend time right now just writing it up. If you trust my editorial judgment to incorporate these decisions, we'll just take care of that on our own time. It's up to you how you want to do that, Madam Chair. I do have the Word document. We could just make the edits right here.
So I would like to suggest to the Commission that we allow staff to make the necessary edits I think Nate is identifying for us what he would take out. Mm-hmm. And then there's a paragraph somewhere in there where we need to say what the results were from today. And I would suggest we give staff the editorial ability to write that up to reflect the decision that we made today. Is there any disagreement with that, or does anyone want to take a different approach? Commissioner Larkin?
Thank you, Madam Chair. I don't disagree. I just want to confirm, the draft report that we were provided has a lot of discussion about the benefits of this proposal. I assume all of that's going to be out, so we're not going to have any substantive discussion about the merits of the proposal. We'll just say we considered it, we decided to take no action, we're going to further study it without any commentary on the merits of the proposal.
And Madam Chair, I will get to that in just a few pages. So,
I think that might be right. We'll let Director Wrights hit that on the page we're on. Does that make sense?
yeah, this is really just talking about the 2021 work plan and talking about basically how, we had a work plan, but things kind of took over. So we didn't really get to work the work plan in 2021 as we intended to. All right, the next section, there's no change. That's the responding to the very significant work of the 2021 Minnesota legislature. And then there's this table. It goes on for pages, but honestly, this is a very brief summary of all the stuff that happened last year. It was a lot of significant changes. So no changes here. Then we get to resolving the half custody status point problem. There's a history of the half custody status point, discovery of the problem, attempts to resolve the problem. And really, I don't think any of this needs to be changed, except that in footnote 28, I cross-reference footnote 69. Footnote 69 is in an appendix. It's going to be deleted. It's in Appendix 2, and Appendix 2 is going to be deleted because Appendix 2 contains the proposal. And this is in an impact section of that proposal. It references the 3 Court of Appeals decisions, including Eubanks, which was part of the motion, and all of which were non-precedential. And that's all going away. So I need to figure out a way to move the content of footnote 69 into the body of the report. So I don't know if I'd put it here or put it a little later on when we talk about the motion. But at some point, I'm going to move the content of footnote 69 so that does not get lost. Everything else, though, in that appendix will go away, including the impact estimate. And the impact estimate, by the way, did go down from 536 to 499 because we changed our assumptions about the status quo. We essentially, because of these Court of Appeals opinions, we didn't feel like our assumptions were valid anymore. We didn't feel like the status quo was the EWS method. We felt like the status quo was the Eubanks method, which the commission has just agreed with. So we're going to have to. So that's why the estimate changed, and that's something that we'll have to incorporate in here. And I think that's also relevant to footnote 28. The existing guidelines are silent on them. Yes, the existing guidelines may be silent on them, but now the commission has spoken on them. So the commission has at least issued, I will take. I mean, this wasn't part of the motion, the word interim, but I take it that the commission is okay with me using the word interim to describe the commission's current position with respect to the rounding issue.
Yes, that would be correct.
And I apologize to anybody who's new to this issue, who's listening to this meeting. This is all probably very confusing. But if you read the section on the half-point custody status problem, I think it explains it in there. So that brings us to the end of that section. So before I get to the end of this section, let me just talk about the next section, the proposed repeal of the custody status policy, if this passes. It didn't pass. I'm suggesting that section in its entirety be deleted. So everything in that section would go away. Instead, what we would do is here at the end, so the paragraph above that section, it starts following a lengthy public hearing on December 16th. So we do 2 things. One is we'd amplify a little bit on really the unprecedented, well, I can't say it's unprecedented because I haven't done a historical review, but I'll just say from my perspective, whopping amount of written public input certainly that we got, and a pretty high amount as these go of oral testimony. I think that should be commented on, just the sheer volume. I did not count up the number of comments. I just counted up the number of pages because that's done automatically. There were 3,600 pages. I will probably rely on the Pioneer Press's count of the number of comments. in terms of, I think it was over 3,500 is what the Pioneer Press reported. And cite to that Pioneer Press article in that. So talk about what we heard at the public hearing, and then really, I guess my plan, what I would propose is not getting too much into the rationale that Commissioner Schnell cited. Now, I did receive from Commissioner Schnell's legislative, I forget Nick's title, but communications director, that I did receive a copy of Commissioner Schnell's prepared remarks. My thought would be more to focus on the content of the motion itself than to get into the rationale, and describe that here at the end of this section. And as I said, just delete the next section. So again, that's something we can do here in real time if you want me to type up the edits, or just leave it at that, or give me other direction if you don't think that's a good approach to take. So what would happen if we were to do that then is the next section would be that the section on the mandate to study sex trafficking, and the fact that we didn't have time for that. So that would be the next section after that. So I'm just going to pause here, Madam Chair, and see if there's any direction from the commission. Either you don't understand what I'm saying, or you have contrary direction to what I'm saying.
Okay, I think to sum up what I heard you say is that, because there's a lot, I think what I heard you say is that your plan is to augment this final paragraph to focus on the substance of the motion that was offered today, and to show that we made a decision to continue to work on this issue, and then you would remove the "if this passes" section from the report, and the next section would be the sex trafficking mandate. Was that correct? Did I get that?
Yeah, yes, and just to amplify a little bit on the public hearing, the volume of the public hearing.
Oh, that's right, yes, and to talk about the volume of comments received during the public hearing. Yes, I think that's fair. Does anybody have any comments or concerns with that approach? Commissioner Knutson, did I see that?
Yes, thank you, Madam Chair. I would hope that we would include the exact language of the motion.
Yes, I agree, and I intend to do that. Yes.
Okay.
And I'm sorry if I misheard something, or what was the mandate about sex offenders?
The mandate was one that we didn't get to this year, which we will be getting to at our next.
All right, that's the leftover from the last session.
Yes, that's correct.
Okay. All right, good. All right, thanks. So I think if we just have the exact language of the motion as moved by Commissioner Schnell, that should cover it. I don't know that needs to be any further explanation, or, I mean, where do you stop then with all the comments that were provided today? So,
yeah, that's kind of my thought too.
Yeah, that's consistent with what we're all saying here. I think that the only thing Director Wright is suggesting that we add is a sentence about the volume of public comments that we did receive in response to the public hearing, following the public hearing.
Yeah, I mean, I think that sort of gives some explanation as to, why the commission's doing what it did. It heard from the public a lot of information, and it took that into account to reformulate the. That's sort of the narrative that I'm going to try to. That's the flow that I'm intending to put across here. Is there was a proposal, it advanced 6-4. We heard a lot of information from the public based on that information, and maybe I would add that based on that information, the following motion was passed unanimously in January, kind of thing. So that's kind of how the story that I would be telling. And then Commissioner Knutson, I have on the screen the sex trafficking review mandate. It's a short. It's a short paragraph, but basically explains there was a mandate to do this. It was given on June 30th. Effectively, if you look at the number of meetings we've had since June 30th, There hasn't been a lot of white space on the agendas. They've all been pretty much taken up. So,
Looks
Good,
like
thank you.
Commissioner Larkin has a question or comment.
Thank you, Madam Chair. Yes, I agree with Commissioner Knudsen that we should just use the exact language of the motion. And Nate, how you've proposed setting it out is good. I think if we start, trying to explain the motion or the justifications, we go into territory where everyone's going to want to be heard, and that's not fair at this point in time when the report is due tomorrow. So I would ask for less commentary and just quote the motion. In terms of, I do have a bit of a concern with the suggestion that we'll just quote the Star Tribune for the quantitative results of the written comments. I mean, I guess it seems odd to me that we wouldn't just count them ourselves. Frankly, my staff and I did that. We came up with 33,611 written comments that expressed a clear opinion on the proposal. In other words, there were some that just sort of talked about this or that and didn't actually say, I oppose or I support. We came up with 3,611 written comments that said either I support or I oppose it. And we came up with 3,402 written comments opposing the elimination, so about 94%. But my point is simply this. It's not that hard to count these things. And it's our obligation to have a public hearing. I don't know why the commission itself wouldn't calculate the results of the written public comments and why we would instead cite a newspaper, and nothing against the Pioneer Press, they've done a great job, but it seems like we should be generating our own numbers, especially when so many commissioners are complaining that there's misinformation presented by the media or to the public. It seems important that we do the work ourselves.
I think the only concern with that is time. Since it hasn't been done up to this point, I don't know if our staff have time to do that. So I think the alternative might be to say something along the lines of more than 3,000 comments were received, or something that's more of an estimate if we are unable to have a total number. Commissioner Schnell, did you have a comment there?
I think if Commissioner Larkin is 3611, I would be willing to just go with that number. I mean, if she representing as a representative of the commission, 3611, if that's what it is, that's what it is.
It must be fewer than 3611. I wonder if Commissioner Larkin misspoke, if it was 3511, because the number of pages is 3,600, and each comment took up at least one page. And some comments took up more than one page. Therefore, the number of comments must be less than 3,600.
Commissioner Larkin?
And that's why I think staff should do this. It's my understanding, and perhaps Commissioner Ladd could speak to this. I think the County Attorneys Association may have done its own calculation, and I thought their numbers were higher than mine. So I question those. So the point is, who knows? We're all respectable people, and we're all coming up with different numbers. And I've added to mine all the ones that have trickled in that Nate has sent out over the past couple of weeks. So.
Oh, yeah. No, I'm sorry for interrupting. Sorry.
I don't know what to say why mine are higher, but I think mine are lower than somebody else's. So it seems important that people make the effort, or at least agree that we had, over 3,500 comments and over 90% opposed. We could do something like that. I think that presents a fair picture of the commentary.
Commissioner Middlebrook?
I guess I just have thanks, Madam Chair. I have a question. Can you get any number from how many emails you got in? Can you count that? Because each email was a comment.
Yeah, I mean, right. Some of the emails were cover letters to comments. We didn't include if the only thing about the email was, please find and close my comment, then we didn't include the email. We just included the comment. Some we did if there was additional information. So I don't know. I mean, I can tell you that I won't have the time or resources to do that between now and when this report is due. So, I mean, I'd be happy to just leave it off and just say what I said when I was describing the public hearing, which was there were 3,600 pages of comments, which speaks for itself. I mean, that's a heck of a lot of comments. I wouldn't say that, but I mean, that's my personal unofficial opinion. And there were over, you know, that represented comments from over 3,000 individuals, which is, you know, a lot. So we could just leave it at that. That's fine. I just thought since there is a published number out there, we could rely on the published number. But I respectfully, and we'll get into this in the next section, don't have the resources to do that. I mean, I haven't had the resources to do that since we finished the compilation of the public record on December 28th, and I surely won't have the resources to do that between now and tomorrow.
Right. Okay. Well, I think that what you have proposed is a rational compromise.
Okay. All right. So then this section on the sex trafficking review mandate we've already talked about. So then we get to MSGC staff's work. I just clarified that the hiring freeze was an executive branch hiring freeze, and we're an executive branch agency. So just very minor changes in that section. The big change was in the data practices summary here, beginning on page 21, PDF page 23. So I'm tempted to call this a supply chain problem, but we did experience a problem with getting some departure data. It was an administrative problem. It wasn't technically on our end, although I'm sure if we had put the request out sooner, we might have identified the problem sooner, that the request did not get passed on to who it should have gotten passed on to. And as a result, we're missing, or at least at the beginning of the month, we were missing approximately 10% of the state's departure data, or departure data from about 10% of the judicial system, basically. So as a result of that, well, the two implications. One is we can't finalize the 2020 data yet. So we can't give you, or we would probably normally give you, or have given you a month or two ago, the 2020 data report. But because of our staffing shortages, we just haven't been able to finalize the 2020 data. Well, because of this supply chain problem, we still can't finalize it. So I'm really hoping that we'll be able to present the 2020 data to you by the next meeting. But in the meantime, what do we do about this report? Well, I think the overall volume information is probably pretty close. So we can still talk rationally about the volume. Sometimes even the volume changes. Like a hypothetical example might be when we get a departure result back, we find out it wasn't a departure. Actually, the prosecutor amended this to a gross misdemeanor. So this wasn't a gross misdemeanor sentence for a felony. This was a gross misdemeanor sentence for a gross misdemeanor. So not only does that change our departure data, it also changes our volume data, because that's one less felony case to report for 2020. But having said that, I'm reasonably confident that if we just call the data preliminary, we can give the data to the legislature, and it'll be something that'll be fairly accurate, pretty close, given that it's preliminary data, if that makes sense. But with respect to departure data, I'm not comfortable saying this is our departure data for 2020. So what I've done is, what I'm proposing to do is just delete the section on departures altogether. It's a pretty big deal. We're essentially referring the legislature in that section, and I'll get to that in a minute, to look at our 2020 data report, which will be published in the first half of the year. Hopefully in the first half of the year. Hopefully we'll get that out pretty quickly, but we just don't have it done now, and I don't want to give them information that's going to change significantly. I don't mind if it changes a little bit, but I don't want it to change significantly, and I don't know whether it will. So that's really the import of the big change, is really the word preliminary in there, not as an editorial comment like it's preliminary at this point, but that's actually going to be in the report, and then this explanation of why it's preliminary. So then we get to the data itself. Very small modification down, again, probably because of that gross misdemeanor. I think think this might be 2 cases lower than what we reported to you in December. So just a little change, but still an enormous decrease from other years. Because 2020 was anomalous, as we point out, we're not reporting trend data this year either, and there's no change to that. So then we move ahead here to, again, very small changes here. The real big change comes in, let's see. Oh, yeah, it looked like there was a misstatement about the life sentences. One of the life without possibility release was not premeditated first-degree murder. Most of these are premeditated first-degree murder, but one was for intentional murder of an official. So here's the departures section. This is page 31, PDF page 33. We talk a little bit more about the unusual delay in obtaining some departure data. And we explain, we ask the reader to refer to the 2020 Sentencing Data Practices Report, Sentencing Practices Data Reports, which will be published in the first half of the year. Another change was to the section on the 5-year presumptive probation cap. And this was, I think, spurred on really by a very valid question from Judge Larkin about, can we get some of these case data information? And the more I thought about it, the more I'm like, I just don't know. I think I was trying to be a little too aggressive about giving the legislature information, the preliminary information that they could use about what's happened with the 5-year presumptive probation cap. But I think I was being a little too aggressive there. I just don't think the data's ready at this point. So I'm telling them, essentially, we're really not telling them much here. So it only applied to offenses that were committed on or after August 1st of 2020. And so to be in our 2020 data set, it would have had to have already been sentenced by December 31st of 2020. So a very small amount of cases and not a representative amount of cases. We even peeked into the first part of the 2021 data set, which really haven't been finalized yet, to see what happened to these other cases. Again, not a representative sample. And so it's really hard to tell. I mean, it does appear from early data. And so it essentially moved it down to footnote 59. The information that we had in the report before is moved down to 59. And I do say this should not be regarded as a representative sample of cases. So rather than report a 90% compliance rate, which we do, we just say, while early data suggests that district courts may generally be complying with the policy, this is highly uncertain. And MSGC will be able to report a more definitive picture of the judiciary's response to the policy next year. So I hope, if I'm open to any criticisms or suggestions on that, but that's the approach that I took there.
So the only thing that I'm sort of wondering there is it's not really just the judge's decision, as to what that probation should be. It's, because most sentences settle with a plea agreement, it's really a system kind of a decision.
So saying judiciary, you'd quarrel with the word judiciary there. I think that's fair.
It feels like it's pointing a finger unnecessarily. No, yeah.
You're right. And I think, I think we do that. We typically in reports go out of our way to point that out, that this is not just a judicial decision. This is really a systems decision that judge has inputs from prosecutors, defense attorneys, victims, probation officers, et cetera, et cetera. So, yes, I think that's a fair point. I will edit that.
Okay, thanks.
All right. Then the firearms reports. So we do have some more data here. We are still looking for data from, and I'm just going to name them here. Douglas, Faribault, Lake of the Woods, Faribault County, not to be confused with Faribault, Minnesota, which is Rice County, and Winona. So those are the 4 counties that were out. We still don't have data on, but I'm thankful to say we did get some data from, there were some pretty big hitters that were still out as of our, when I sent this out to you in January 6th, and thanks to the hard work of the Minnesota County Attorneys Association and its executive director, Bob Small, we've really closed that gap quite a bit. So we still have 4 counties, which is too bad, but, you know, and if we get them, if they're in Katie's inbox by tomorrow morning, we'll be sure to put them in the report. So instead of a small decrease, we're now looking at a small increase. So 2021, so this is fiscal year, just so it's clear, this reporting requirement that the legislature imposed on county attorneys is to report for the year of July 1st, 2020 through June 30th of 2021. And obviously that's right in the heart of COVID, but it was a slight increase in cases rather than a 4% decrease in cases.
I'm actually confused. So is the chart on here still need to be updated, or?
Yes, this chart, so what I'm showing you on the screen right now is the January 6th draft. So this is what you got in your email inbox. I will pull up the more current version right now. If I have it. All right. So I'm showing you this is actually the Word document. I haven't made this into a PDF yet. These numbers are correct on here, but I need to redo the diagram so it actually reflects the numbers. And then here's the chart. So the number that we have without those 4 counties, so this is subject to increase, is 1,074. So that's a 1% increase from fiscal year 20. So those are
Okay.
Those are the changes, and the so 56% of those cases where the mandatory minimum applied to, the county attorneys report that the mandatory minimum prison term was imposed and executed. And I'll just say, although the footnote explains it very clearly, mandatory minimum isn't, that's the term that's used in the statute, but it's not actually mandatory. There are clear provisions in the statute for the waiver of that mandatory minimum term.
Okay.
All right.
Thank you.
So that's really the only update from the January 6th version. So I appreciate you pausing on that. All right. So back to the PDF. So really, I think the only other change is to delete Appendix 2 and renumber the appendixes that follow as Appendix 2 and 3 instead of 3 and 4. So I think that's how it works. And that's, let me get to Appendix.
Okay, so do members of the commission have a clear understanding of what the content of the report will be? Are there any questions that need to be answered at this stage? If there are no questions, then I would entertain a motion to approve the report to the legislature with the changes as outlined by Director Wrights as we rolled through it.
And Madam Chair, if that could include just sort of general permission to make editorial changes not inconsistent with the guidance provided by the commission at today's meeting.
Yes, I think it would include that. Do we have a motion? It looks like Commissioner Middlebrook has made that motion. Do we have a second? Commissioner Schnell seconds. Do we have any discussion on the motion? All right, hearing none. Nate, when you're ready, if you wouldn't mind calling the roll on that.
If I could just have a moment, please.
Yeah.
All right, to the Middlebrook motion to approve the 2022 report to the legislature, subject to the changes described in today's meeting, with authorization for staff to make editorial changes not inconsistent with guidance provided to staff in the meeting. Estrada?
Yes.
Estrada, yes. Blakey?
Yes.
Blakey, yes. Hansi?
Yes.
Hansi, yes. Knutson?
Yes.
Knutson, yes. Ladd?
Yes.
Ladd, yes. Larkin?
Yes.
Larkin, yes. Middlebrook?
Yes.
Middlebrook, yes. Moore?
Yes.
Moore, yes. Morath?
Yes.
Morath, yes. Schnell?
Yes.
Schnell, yes. Chair Mitchell?
Yes.
Chair Mitchell, yes. Madam Chair, there are 11 votes in favor, no votes opposed.
And with that, the motion is approved unanimously. Is there anything else that you need from us on that front?
No, Madam Chair, thank you.
All right, great. So the next item on the agenda is the Governor's Council on Justice Reinvestment. It's really an information item. I mentioned to the commission a couple of meetings ago that there was a justice reinvestment action going on in the state. There's actually a different group, a delivery service, what's it called? Delivery system work group that has been working with the Council of State Governments for most of last year, definitely all of last fall. The Council of State Governments has been reviewing data and information about how probation works in Minnesota, what the resources are, how they're allocated, what the funding formula is for county support of probation services, because in many locations in the state we have a sort of a mix where probation is provided sometimes by the Department of Corrections, sometimes by county probation agencies instead. So that group has been working for several months to sort of understand the picture of what's going on in Minnesota. That group will be developing recommendations and bringing those forward to the council, of which Commissioner Schnell and I have been appointed as members. And the council, I think, will be making final recommendations to the legislature a little bit later this year. We have tried to have CSG on the agenda for 3 meetings to come in and give some preliminary data. We're going to try again next month. We'll see what we can do. We have a lot on our plate, so we'll try again. But hopefully this commission will also have an opportunity to see much of the data and findings that group has put together, that the Council of State Governments has put together. I've actually only attended 1 meeting, so I know less about this than the average person. Commissioner Schnell, is there anything that you want to add, since you've been part of this for a longer period of time than I have?
No, Madam Chair, I think you covered it right now. It's a lot of the data is being reviewed. The Delivery Systems Working Group is, in fact, started meeting today at 3 with, again, some updated data. And I think it ultimately would be helpful to bring back to the commission just to look at some of the data statewide around what's happening with probation supervision, how it's different by delivery system, and even outcomes and different practices that might make things more effective and efficient.
All right, thank you. Any questions from other commission members on that front? All right, we'll keep working to get CSG here so they can share with this commission some of the data that's been shared with that work group. All right, item number 8 is options for consolidating annual public hearings. I believe Director Wrights put this on the agenda based on a comment that I may have made at the last meeting. But maybe I'll let Director Wrights, you maybe explain the issue, and then I can comment on it if that doesn't comport with what I was thinking.
Oh, thank you, Madam Chair. Yeah, it just seemed like there was some interest in, I guess, kind of avoiding our current calendar with respect to public hearings. There's really a couple of problems with it. One is it divides up the calendar by having a summer public hearing and a winter public hearing, basically, and makes it kind of hard to keep in a flow. And another thing that I heard at least was a concern about, because we were talking about the minority report, assuming that it passed, and really that everything's very compressed, and there's really not enough time to react to what was done to write up the report to the legislature, essentially. So with respect to the first problem, I mean, well, I mean, I guess I've included in your materials the statute that Minnesota Statute 645.02, which says essentially that the default effective date is August 1st for statutes in general. And that's certainly how criminal statutes are typically written. You'll recall this year the legislature changed that to September 15th upon your recommendation because August 1st just wouldn't have worked for getting things out. But, it doesn't have to necessarily be August 1st. So say, for example, the legislature were to change that, I would say both in this statute for criminal laws to say January 1st, then you could just have the December public hearing and be done with it. That would be the only public hearing you'd have to have. But of course, that would require legislative action. So that would be one solution, is just to postpone effective dates until January. Another solution that may be very unpalatable to practitioners would be to just not have the summertime public hearing and just make all the rankings effective January 1st, and publish the guidelines on January 1st, which would basically mean that all the new offenses would be unranked for a period of 5 months, so that would be a problem. But that would be one solution to the public hearing problem. I also wrote up a calendar that was kind of a idea, just sort of a mental project of how could you, this wouldn't solve the 2 hearings problem, but it would at least solve the compressed time schedule problem. So it would have a public hearing the week after Thanksgiving, and then the commission would have time to meet right after that, the following week, or maybe it'd have to be bumped 2 weeks to avoid the judicial conference. But the commission would then vote on it, and then you'd have time to sort of regroup based on the decisions the commission made, and spend some time wordsmithing the report to the legislature before that was voted on in January. So that would be an incomplete solution to the problem. You'd still have 2 public hearings, but and there'd be another commission meeting, because instead of consolidating the December public hearing and meeting, you'd basically be dividing it in 2. So that was just a thought I had, Madam Chair. But I guess that's really all I have as far as introducing the problem to the commission. I guess it's up to you how you want to tackle it, if you want to tackle it.
Yeah, I appreciate your putting some thought. I think I will be honest that given the other issue that was on the calendar today, I didn't really have a lot of time to think through what some options are, and I personally would like to think more about this. But I will say that what my concern was, the comment that I know that I made in December was, that I feel like because we have this hearing in the middle of the year every year, because basically what happens is we do policy work at the beginning of the year. We start in January or February doing policy work, or technical changes if that's what the order of the day is, right? And then our work gets interrupted in the middle of the year because we have to rank crimes, and those are time sensitive. So then that whole process takes a couple of months. We get off track with policy. Then we usually take August off, we come back, and we kind of have to regroup and try to remember all that we were talking about before. So we lose our momentum on the policy discussions, and it would be great if we could figure out a way, I think, to have one hearing per year, one cycle, so that we can have a more continuous process that isn't interrupted in the middle. And I think you mentioned one solution is maybe we recommend to the legislature they change the effective date of when crimes become effective. I would imagine there's other solutions to that as well. I just haven't personally had the bandwidth to think about what those are before this meeting. I don't know if others have comments, but that was really, that's my concern. and that's what I was thinking we should talk about. Do others have comments, or?
Madam Chair?
Commissioner Knutson?
Well, just in general, if we could have a better understanding of what the deadlines are. So we're responding after the legislature passes the new statutes, new criminal offenses, whatever. They're either effective August 1st or January 1st, correct?
They're usually all effective August 1st.
Okay, and they want the rankings by the effective date of the offense?
Madam Chair, I should have probably covered that. I'd be happy to sort of cover that from soup to nuts.
Sure, go ahead.
So that's a great question, Commissioner Knutson. So basically, there's two types of changes that, the way I think of it is, there's legislative initiatives and commission initiatives. Legislative initiatives take effect. The commission basically gives those to the legislature after the fact. Those changes in response to legislative initiatives, like for example, there's a new crime of child torture. How are you going to rank child torture? That goes into effect immediately. So child torture is already ranked as the commission decided it was going to be ranked back in September. It took effect September 15th. And then that gets reported to the legislature after the fact. So it took effect on the date ordered by the commission. Typically, that's August 1st. This year, it was September 15th, and is reported to the legislature after the fact. The other changes are basically commission initiatives. An example would be repealing custody status. That would have to have been reported to the legislature by January 15th of the year in which the commission wants it to take effect. And then the date is always August 1st. By law, it takes effect August 1st of the following year. That gives the legislature an entire session to basically decide whether or not they want to veto it. Does that answer your question, Judge Knutson?
So the commission initiatives need to be reported to the legislature by January 15th for an effective date of
The following August 1st.
August 1st. And the legislative initiatives, the laws that are passed, need to be ranked by when?
It just says within the preceding session. So basically, the commission has until I don't know. I mean, it's kind of an interesting question because we had one year where the commission had multiple special sessions, and then it's like, well, what is the preceding session? We still assume that the commission can rank anything that was essentially done that year. But I don't think you can do something the following year. You can't use that rule to rank something that was passed the year before. So I've always understood is you have to do it that year.
Well, let me clarify this. The laws go into effect on August 1st.
Typically.
So in order for those laws to go into effect and also be ranked within the guidelines, that August 1st is effectively our deadline. But what we end up having to do is back up then the process that we're required to go through. So we have to have a public hearing before that date. We have to also, make a decision on the ranking and give notice of that public hearing. So essentially, we need to make a decision in June on what all the rankings are. Then we go through the public hearing process, and then the new guidelines come out on August 1st.
Right.
But in some years, when the legislature has taken longer than usual to complete its work, that has forced our guidelines to come out later. We've done that process as quickly as we could under the circumstances. And so that's how it plays out.
Yeah, so the reason the June meeting is the Thursday after the first Tuesday in June is because if you do the math, the constitutional math on when the legislative session has to end and how long the governor has to act on the legislative session, it's basically that first Tuesday in June. So we should know by the first Tuesday in June what passed during the session. And then on Thursday, you meet and immediately figure out what you're going to do about it. Send it to a public hearing. There has to be a 6-week wait, essentially, between the date of your decision and the public hearing. And then there has to be a 1-week wait after that. So that's why we have the calendar now is the Thursday after the first Tuesday in June, 6 weeks later, the public hearing, a week after that, which is often very close to the end of July, the final decision, and then boom, we publish the guidelines on August 1st. So it is a pretty tight schedule there in the summertime.
Okay, that is very helpful. That makes a lot of sense. Puts it in perspective. We would just have to adjust our meetings if there's special sessions that pass additional criminal justice initiatives or new crimes.
Right, and that's
Right.
that's when you joined the commission, Commissioner Knudsen, that's exactly what we were in the middle of, was an adjusted calendar. We were kind of trying to keep up.
It looks like Commissioner Estrada has a question or comment.
I too would like a little bit of time to further think about this. Just in observation right now, and given the situation that we're in with the custody status point, I think one thing that pops out is we really need to spend the time to research and get the data and weigh everything out. And I think that's true too when we're trying to rank offenses. So if we had to decide today, I would think that my gut would tell me I would like to look at asking legislation to make new crimes effective January 1st. But I do like more time to review this.
Any other comments or questions?
Yeah, we definitely, Madam Chair.
Commissioner Knudsen.
Yeah, we definitely have to spend a lot more time on this, I think. I just don't see us asking the legislature to change the effective date of crimes. That's got to be centuries old. That's just a date that the entire system, both legislative and criminal justice, is used to. It's just ingrained in everyone's mind that that's the effective date coming off of a legislative session. So there's uniformity and clarity in the application of all of these new offenses.
All right. So I think I'm hearing consensus, like let's continue to think about this and we'll put it back on the agenda. But today was really ended up being like, what's the problem? So now let's start to all think about what could we do? What are some potential solutions? And then we can talk about those at a future meeting. Sound good? Okay. All right. Great. Thanks. Next item is options for future meetings, for February meeting, right?
Yeah, so this is a little more time sensitive, Madam Chair. So we have been the hosts of the Senate, the guests of the Senate for several months now, when they have not been in session, using this really nice room and with I think really good technology for hybrid meetings. In my assessment, Madam Chair, maybe from your end you have a different perspective, but that's not going to be true next month because the legislature will be back in session. So we have reserved a room, which those who have been in the commission in a while will remember. It's Lady Slipper Conference Room in Centennial Office Building. The problem with that is that Centennial Office Building is currently closed to the public, and I really don't see that changing between now and our February meeting. That really presents some issues as to what we're going to do. So I've given you some statutes, 13D.015 and 13D.021. So 13D.015 is the statute that we're meeting under right now. That's the regular old electronic meeting statute. And that has a few requirements that I've highlighted. One is members of the public have to be able to be present at the regular meeting location. Recall, that doesn't work at Centennial because the building is locked. And I mean, unless we were to somehow have staff at all three exit doors letting people in, I just don't see that happening because they'd have to be there the whole meeting. Anyway, I just don't see that public, and I'm not even sure they'd allow that, frankly, but, so public basically can't be present at the regular meeting location, and at least one member of the entity has to be physically present at the regular meeting location. So, for example, you, Madam Chair, or somebody else has to be able to get in. Again, it's locked to the public, so I don't know how that would work. I could probably get in because the security guard's friendly with me, and he usually lets me in the building if in a room if I asked to, but I don't know that anybody else could. The other requirement in the regular old remote meeting policy says there has to be at least 10 days notice, which we haven't had a problem complying with that. So the other statute is the 13D.021. So that's the meetings during pandemic or Chapter 12 emergency. This is the law under which we were meeting completely remotely from April of 2020 through June of 2021, I believe. And then we went to hybrid after the emergency no longer existed, after the governor lifted the emergency. Hybrid under 015, that's the other meeting. So I'd like to bring up this statute again, though, to see maybe we should go back to that. So, and I don't know if it'd be helpful to see it on the screen or if you all have it, but it's 13D.021. So the first requirement in subdivision 1(1) is that there has to be a determination by the presiding officer, chief legal counsel, or chief administrative officer. I take it, Madam Chair, that you are the presiding officer, that Matt Frank, who's way too busy to be here, is the chief legal counsel from the Attorney General's office, and that I am the chief administrative officer. So one of us has to make a determination that an in-person meeting or a meeting conducted under 13D.015, the hybrid meeting policy, is not practical or prudent because of a health pandemic or emergency declared under Chapter 12. So right now there is no emergency declared under Chapter 12. So there would have to be a determination that there's a health pandemic. I assume there is still a health pandemic. I'm not a public health expert. I've heard people say that, oh, the pandemic is over. Kind of, I take it they were speaking more in a politically rhetorical sense than in a technical health pandemic, public health sense. I haven't heard any public health authority, whether it's the World Health Organization that initially declared the pandemic, or the CDC, or Minnesota Department of Health, declare that the pandemic is in fact over.
I think I get the gist of it, and we're kind of running out of time, so
I'm sorry.
I just want to get to the...
That's the first requirement. So then the other requirements is that there has to be a determination that it's not feasible for members of the public to be there. I think the fact that the building's locked means it's not feasible. And then it has to, and if that's true, then you can hold the meeting entirely remotely with respect to the members of the public. And then with respect to everybody else, it can be held remotely if it's not feasible for, in this case, I could be there. And I think it probably is feasible for me to be there, but I don't think it's feasible necessarily for anybody else to be there. So I think what I'm saying is, I think if I just sat in lady slipper all by myself next month and everybody else appeared remotely, we'd be complying with 13D.021, assuming that somebody didn't declare the pandemic to be over with between now and then, and I don't think that's going to happen. So if everybody's okay with that, and that this only requires a 3-day notice. But if everybody's okay with that, I mean, unless there's an objection, I think we kind of have to go back to remote meetings, basically, for the time being.
Commissioner Moore, I think you wanted to make a comment.
Thank you, Madam Chair. Director Wrights, I believe I could get to Lady Slipper if you needed to have somebody there from the commission.
Yeah. Well, for this statute, 13D.015, the hybrid meeting rule does require a member of the commission, but 021, it's good enough if I'm there. So
right.
You'd be welcome to come, but it wouldn't be necessary. And if you weren't there, I wouldn't have to wear a mask. So
yeah. So, all right. Let me cut this short. I feel very comfortable declaring that we are in a health pandemic, and that it is impractical or imprudent for us, any members of the commission or the public, to attend that meeting. I don't actually think you need to be in Lady Slipper. I think we could be all remote, and that is certainly true for February. We've tried all these different locations, and the problem is we can't get hybrid going just anywhere. That's really, there's no, where we can actually get public to come in and also have the members of the commission there. So I am totally comfortable making that that determination for February, and we will continue to monitor the situation as we go.
All right. Perfect. I was hoping you'd say that.
All right, Executive Director report.
Madam Chair, really, it's just one carryover item from last month. So I have finished my Campaign Finance Board disclosure. It's come to my attention that we did not notify the Campaign Finance Board was not aware of 3 of the new members from last year. They were tracking Officer Blakey joining, but not the. So who would that have been? So Commissioner Knudsen, Commissioner Morath, and Commissioner Moore. So you probably haven't gotten an email from them. You should be getting it soon. I just notified them this morning that you're on it, or an email or a letter. I'm not sure how they communicate, but everybody else should have gotten a letter, and you should have the disclosures due by the end of the month. So if you don't hear from them, I'm going to be on vacation next week, but if you don't hear from them by the end of next week, please contact me at the beginning of the following week, and I'll make sure you get in touch with them before the end of the month.
Commissioner Moore?
Director Wrights, Judge Knudsen and I are already required to file. Given our status, I assume we don't have to file a second statement for purposes of the participation on this board. I mean,
I would assume so.
I would assume not.
Hopefully they're linked.
Commissioner Middlebrook?
I don't know, you probably do want to check on that because we have to, when we fill it out, it says that you're a member of this committee.
Oh, that's right.
It says right on there, so it may be that you have to do both times.
I believe, however, they are linked because I have both for my regular role and then this one, they're on the same form, same everything.
So it's possible that if they didn't know you were on the commission, they didn't list that, or it wasn't listed, and so maybe they'll need you to submit one
Yeah,
to get caught up, you know?
I'm
We'll
guessing
see.
that's the case. Thanks for the clarification.
Yeah. Okay. Anything else in your
No,
executive
that
director
concludes my
report?
report, Madam Chair. Thank you.
Okay, then I think we're on to public input.
All right, so, excuse me just a minute, Madam Chair. Jill, how many members of the public do we have right now? Okay. So I'm a little concerned about feedback, but maybe 23 is manageable. So, let me. All right, so for everybody who's listening, who's a member of the public or not, anybody who's listening on this to this meeting, in a moment your microphones are going to be unmuted. So this is going to change from being a radio to a walkie-talkie. Basically, we're gonna be able to hear what's being said on your end. So if you do not wish to make a comment, please immediately remute your microphone to reduce feedback. If you do wish to make a comment, please state your name and the chair will call on you one by one. So again, I'm about to unmute your microphone, so if you don't want to make a comment, please mute it again to reduce feedback. I'm unmuting your microphones now.
Matt Majowski.
Okay, Mr. Majowski, please go ahead.
Thank you, Madam Chair. I apologize that I'm difficult to understand. I'm still recovering from surgery that I had after our last meeting, which makes it difficult for me to talk at times. So I hope you can understand what I'm about to say.
Yes, we can. Thank you. Go ahead.
Yeah. Thank you again, Madam Chair and Commissioners, for all your work. I appreciate what you do and especially what you've discussed and decided today. My question is more about logistics concerning the rounding down of the half custody status point. Should we as practitioners wait until the memo is prepared and sent out concerning the Eubanks decision? Or can we, as soon as this meeting is over, can I give direction to our practitioners commissioners in their prior record memo reports or PSIs to reference the decision and round down the half custody status. We know it will take time for the electronic worksheet to reflect that. But so could I please get some direction in that area? Thank you.
Take it. Like, it's not
All right.
you to do that.
I'm going to have Director Rice respond to that in a moment. For real quickly, if you're online and you're interested in talking, please hang on. But if you're not interested in talking, please mute. We can hear a conversation.
Actually, Madam Chair, why don't we do it the other way? If anybody else other than Matt Majovsky is online and wishes to speak, please state your name now. Otherwise, I'm going to mute everybody and then unmute Matt Majovsky. So please state your name now if you want to make a comment. Otherwise, you're going to be muted.
Kelly Jansen.
Ann Burgett.
I mean, they have the texts, but like, it's not like invasive. It's not like you have to like.
All right.
Okay, I think
down your throat.
Get the three names.
Okay. So what were those names? Did you get those, Jill?
It was Ann Burgett.
Ann Burgett. I heard like a Ellie Johnson, I think.
Okay.
And there's one other person.
All right. I'm unmuting Ann Burgett.
Okay.
Okay. And then let's see. I'm unmuting Matt Majowski. Oh, he's unmuted already.
Kelly Jansen. There's a Kelly Jansen.
Kelly Jansen. Okay. I'm unmuting Kelly Jansen. Was there another name? I just felt like we were getting somebody's personal call. I didn't
Yeah, I
want
think
that on the
that's
public
right.
record. So.
I think that's right.
All right. Well, I guess we can go back at the end. What I propose, Madam Chair, is that you just take these three people and then we'll do a last call at the end. I'll unmute everybody again, but
Okay, so we'll answer Matt's question, but we'll let the other folks talk first. So let me call on Ann Burgett, please.
Okay. My name is Ann Burgett. I'm a South Minneapolis resident, and I wanted to thank the members of the commission who spoke up so vigorously on behalf of crime victims. I am a crime victim, although not recently, but I do have to say that although the crime that I experienced, home invasion, took place in 2006, the impact of it stays with me to this day. I appreciate the considerations that all of you have mentioned here, and I recognize that you're working under adverse circumstances. I think that it's very wise that you postpone some of the decision-making for further discussion, particularly because some of the data that is available to you is only data from 2020, which is significantly before the rapid rise in crime that we're experiencing right now became apparent. Thank you very much for the time that you're putting into this. I appreciate being able to listen. Thank you.
Thanks so much for attending today and providing your comment. Kelly Jansen.
Thank you. I just had a couple of questions. One is, when does the Governor's Council on Justice Reinvestment meet, and is that open to the public?
So the Governor's Council is scheduled to meet on January 21st from 2:30 to 4:30, and also January 27th from 2:30 to 4:30. It is open to the public, all of the meetings are being held remotely, and they are being live streamed. So it's accessible to the public. I would recommend that you connect in with Senator Rosen's office, because they are in control of the meeting.
Okay.
That meeting.
And then I have one other question for Brooke Morath. You had cited a study that said 6 out of 10 victims say they don't want the longest sentences applied, and I'm just wondering where that study is.
Commissioner Moran, do you have that study available?
So that study, it's a national study as well. It's put out by the Alliance for Safety and Justice, and the title is Crime Survivors Speak, the first ever national survey of victims' views on safety and justice.
We can also put that in the minutes, a cite to that in the minutes, since it was asked about in public comment, and then you should be able to get to it on the website. I think that
Okay.
might be the easiest way to make it available since someone has asked for it.
Thank you.
All right. Thank you. Thank you for your comment today. And I think that takes us back to Director Wrights. What direction you would like to give? I know that you're handling, how guidance is given to folks in the field. So,
Thank you, Madam Chair. And Matt, you heard the commission's directive, so it's effective immediately. The minutes won't be approved until next month, but we will. I hope to put out the new guidance tomorrow before I go on vacation. So there should be something on our website tomorrow. But it would be immediately effective if you're still doing PSIs today. It doesn't change any of the components of the criminal history score. It just changes that final number, so it's rounded down.
so it won't be reflected on the worksheet, is what you're saying, but
Yeah,
the case law already exists, so that case law is there to provide guidance to the field as well already.
Right. Mm-hmm.
Well, thank you very much. I lost my connection, so I didn't know if the question was already answered. So I appreciate that, and yeah, we understand that it may take some time, and I wouldn't expect you to have to push out that memo that quickly, given all the rest you have to do tomorrow before you're out. But thank you very much for that.
Thanks,
Madam
and
Chair, may I also respond?
yes, I just saw your hand up. I
Okay,
apologize
sorry
for
about
missing
that.
that earlier. Commissioner Estrada.
Thank you, Matt, for your comments and your questions, and I hope that you have a speedy recovery. I will say that I'm in constant communication with MACAC directors. Some of those directors have asked that all communication be distributed through them. So I would encourage you to touch base with your director on terms of how to spread that to spread the news within your department. But after this meeting, I do intend to write to all the directors about what happened here and let them know that a memo with more specifics will be coming their way as well.
All right. Thank you very much. I think that's a good idea. I don't want to jump the gun. Knowing that something will come soon, I can kind of talk about it. And we want to, of course, present this in a consistent manner, adding a specific kind of consistent note to our reports that, example of we have custody status point is rounded to 0 per state the Eubank, something on that order. I think it would probably be prudent to wait a little until we get that clear direction.
Sure.
Thank you again.
And Matt, I would say it'll probably get published on our website tomorrow, but the person who would push it out, I think, will be on leave tomorrow, so it might not get pushed out until Tuesday.
Okay. That's fair. Okay.
Yeah, for sure, fair. Yeah. Thanks.
And Commissioner Larkin has a question.
Oh, I'm sorry, Commissioner Larkin?
I just have a suggestion for Matt. Take it for or for Nate. Take it for what it's worth. I'm a little concerned about describing the Court of Appeals cases as presenting a rounding rule, because the cases don't really say they don't say round down. The most recent case simply says if you have somebody who, for example, has a 1.5 score, you can't sentence them as if they have a 2. Now, the practical effect of that is rounding down, but I'm afraid that if we describe it as the cases say you have to round down, it might lead to confusion to the extent we have other rounding rules. So I'm just throw that out for consideration. The cases don't say round down. They simply say you can't go up to the next number.
How about this? If the final criminal history score ends in 0.5, the 0.5 shall be ignored. I mean,
That's perfect, yeah. I just, when we say rounding, because we have other rounding rules, and that's
Right.
been part of the discussion, we don't want to create confusion by having different rounding rules. It might be good to avoid rounding in the explanation. I like the language Nate just provided, just a suggestion.
All right. Commissioner Middlebrook?
Thank you, Madam Chair. Just to clarify, Eubanks does say to round down, so they use round down in that opinion. The other two don't, I agree.
Yeah, and it's non-precedential. I will say that from my perspective, the motion today has more weight than Eubanks because Eubanks was non-precedential, but no offense, Judge Larkin, but no offense to the Court of Appeals, but I mean, you did say round down in the motion, but I think the important thing is the effect, and I will try to communicate it in a very clear way. You'll have a chance to review our communication next month, and if you didn't like it, we can adjust it. But I do think it's important that the field know immediately that half custody status points are to be effectively disregarded.
All right. I think that takes us to the end of the agenda.
Do we want to try unmuting just in case I miss somebody, or are we?
We certainly can. I mean,
Okay.
I'm not against that.
All right,
You
so
wanna
members
try
of the
it one more
public,
time?
I'm sorry.
Go
Members
ahead.
of the public, out of an abundance of caution, we're going to try unmuting you again just to make sure we didn't miss anybody. If we did miss you, if you do want to make a statement, please state your name immediately after I say that we're unmuting all microphones, which is going to be in about 3 seconds here. So we are now unmuting all microphones. Please state your name if you wish to make another comment. All right, it looks like nobody's responding, Madam Chair, so I think we can move on.
Okay, sounds good. All right, with that, just making sure I'm not missing something on the agenda like I did last month. Yeah, with that, we're at the end of the agenda. And so the meeting of the Sentencing Guidelines Commission is adjourned, and I'll just remind everyone, I will see you all online in February. Thank you.
Thank you. Thank you. Goodbye, everyone.